Now, this has been a point of debate across the day on social media and even in physical places. And to get some clarity on this and some of the issues that you have raised, we're now joined in studio by Daniel Konyango, who's a Deputy Director in charge of Legal and Regulatory Services, I should say, at NACADA. Thank you for joining us on NTV tonight.
Thank you, Daniel.
So, the first thing, for the sake of clarity, is this just full of proposals? Is it, when you know, the thing was that people are told it's a policy, but then it has been said afterwards that no, it's not final. So what exactly is it?
All right. Thank you, Dan. Good evening, viewers. For purposes of clarity,
yes,
there is no ban imposed today. The legal position with regard to alcohol and drug control is as it has been to date. What we have today that was launched is a policy, a set of policy proposals that are meant to be implemented by various players and in various alternative strategies. This proposal forms the basis of futuristic engagement across a wide spectrum of interests, and the options that will be employed in implementing this policy include legislation, which is just one of the options. We'll also have the option of administrative action, the option of community mobilization and advocacy across a very wide spectrum of areas like health, administration, social work, education, and even youth affairs.
So when you say that there are proposals meant to be implemented, it almost implies that, okay, then these are pretty much good to go. It's just the relevant agencies or bodies to do that. So between now, the launch, which was cited as the launch of a policy, not of policy proposals,
yes,
and when they should actually be effected, what needs to happen?
All right, thank you. Now, the pace and the nature of activity to be undertaken to implement this policy depends, one, on the option that each player or actor will have picked. For instance, if an actor will have picked legislation, we have about 49 legislatures in Kenya presently, 47 county legislatures and the 2 houses of parliament. So each legislature will have its own unique programs, the pace at which the legislation and even the extent to which the changes or enactment of new legislation will come into place depends on the unique attributes of the legislature. Mark you, issues to do with drug and alcoholic drinks control is devolved, and policy issues remain at the national level. So this activity this action that was taken by the national government today then sets all players with a foundation, a legitimate foundation, to undertake whatever option they pick to implement this policy. If it's administrative action, it will depend on the pace at which the administrative action is to be taken. Community mobilization, this is going to be an ongoing process. So it depends on the activity as well as the policy actor. Okay,
now, we saw, if you look in the document, we've seen that they speak about there was wide-ranging consultation and the likes.
Yes.
When and where did this happen? Because you talk to retailers, they say they were not involved, yet they are very affected. So when and where did this happen, public participation?
All right, thank you very much. Now, this policy actually draws from an undertaking that Kenya made as far back as 2010, actually in the year 2010, at the World Health Organization, which passed a resolution which was adopted by 193 states, laying down strategies to reduce harmful effects of alcoholic drinks. So that has been the policy watershed against which the current legal framework has been operating. Now, this policy that was generated at the WHO in 2010 has laid down 10 strategy areas. And those strategy areas are what have been captured in the Alcoholic Drinks Control Act, which has also been replicated in almost 41 county governments. So it is not true to say that this is a new or a novel invention by NACADA or indeed the national government. Now, when it came to domesticating this resolution, remember this resolution was taken in 2010. Now, we have the constitution that came into place in 2010, but then rolled out by the county governments in 2013, 2014. Now, there's the provision of Article 43 in the Constitution that guarantees social and economic rights to every individual, and one of these rights is the right to health care. Now, alcoholic drinks and drug control, its main locus actually is on health care. So, this policy rolls out and gives an opportunity for all state actors and even non-state actors to secure and grant to each and every individual the right to health care. This includes those who partake in alcoholic drinks so that their strategies to ensure they don't escalate into abuse, protect those who do not undertake alcoholic drinks like the children, the vulnerable populations, and even those populations that opt not to be part of consumption of alcoholic drinks.
Sorry, I just want to interrupt you because I think the core question here we are asking is, when did public participation happen for this to be put on paper?
All right, thank you. The public participation for purposes of this policy expressly took place in the last 2 years. It was an elaborate process that involved national government actors, county governments, civil society, professionals. We went round, the national government, coordinated by NACADA, went round all the regions undertook public participation, and this ran from the year 2023 all through to 2024. This policy was finalized in August 2024 and eventually approved by the cabinet about 1 month ago.
So we have got retailers who are saying they were not involved in this. So they've actually sort of been caught by surprise when it comes to some of the stipulations of this, which affect them very directly. Are we saying that they are misinforming us?
Well, we cannot rule out instances where a particular person did not participate, but the opportunity to participate was granted to all members of the public. Indeed, we had all players involved at the regional level, culminating into a national forum at the Kenya Institute of KICD before this policy was eventually finalized and then taken to the cabinet for approval. So it is not true that public participation did not take place.
So by the time we are seeing all this uproar, don't you as NACADA see that there's something amiss where we've got all these people who are complaining and are caught by surprise, saying that some of these proposals, as you say, are out of this world, so to speak? Doesn't that speak about a populace that did not know about this?
Well, the saving grace done is that in the event that somebody did not take part in this process, all these implementation alternatives we've laid down have got elaborate public participation avenues going forward. Legislation has got one of the most elaborate public participation opportunities. So whenever a county government or even the national government or any agency for that matter will opt for a legislative approach, there's ample opportunity to take part in, to undertake public participation. So all is not lost. There's ample opportunity for whoever is getting to know about this for now to get to the policy actors at the time they'll be rolling out the alternative they'll have picked to implement this.
So there's still a chance for public participation. It almost sounds like it's a saving grace for what was not done before.
Not actually. The policy, as indeed any governance, public governance processes is required of presently, undertook the processes involve public participation. As I've indicated, all these options that are available for action going forward also have their own ingrained public participation opportunities. So it's not a saving grace for purposes of redressing a lapse in the past, but for purposes of informing and enriching future engagements.
Okay, so there's something that in the story done by my colleague Vita Ngaruya, where we had Otieno Molo saying that there's a concern about the raising of the age of legal age of drinking to 21, when we have the Constitution speaking about 18. Is NACADA in a position to legally, or the government on its own, in a position to actually change such things without breaching the Constitution?
All right, thank you very much. Now, the age 21 is not a unique proposal currently. Number one, this age is based on cogent scientific and behavioral studies worldwide. Indeed, the WHO resolutions that inform this policy at a global level actually bases a lot of its strategies on health issues. Now, it is scientifically stated and proven that the human brain stops or develops fully at age 25. So at age 21, we are having people or young populations which are still quite vulnerable, still developing. Now, beyond scientific evidence...
I'm asking more of the legal.
Yes. Beyond the scientific evidence, we have comparative positions. The US, which is the ideal model of civil liberties, has got the minimum drinking age at 21, despite it having other aspects of majority age for other engagements like driving, voting, and so on and so forth at a different level. In Africa, we have various countries whose minimum drinking age is different from the universal.
So I think my question is what the government is proposing to have vis-a-vis what the Constitution talks about. In terms of the 18-year, so is there, without comparing to other countries, because that was a very specific case, when you say let's move it to 21 years old,
yes,
the Constitution talks about the age of consent, etc., being 18. Do you have the legal leeway to change that for this one instant?
Well done. It does not boil down to legal competence to change the age, constitutionally or on a statutory point of view. McHugh, we are talking of a policy directive for actors going forward. Dan, you recall, in Kenya, despite the age of majority being 18, under Children's Act, the parental responsibility of a child in Kenya currently still can be extended to beyond 18 years of age. This means that the Constitution can still legally mandate a parent and grant a person beyond 18 to extract legal duty from the parent, notwithstanding the fact that they are 18, depending on the circumstances at hand. For instance, if the child needs continual care beyond 18, like still going to school, then the parental obligation is extended to beyond the age of 18, despite the age 18 being the declared age of majority.
Okay.
Yes, sir.
Okay, and then I think for the sake of clarity, I guess you've said that none of this is enforced now, and it's now with the legislators, that is both houses of parliament as well as the county assemblies.
Yes, sir.
All right. Thank you very much, Daniel Konyango, the Deputy Director in charge of Legal and Regulatory Services at NACADA, who's been speaking to us and responding in regards to the proposals that NACADA has put out in the policy document, which has caused some uproar, both online and even in person, and just a lot of questions around what the rationale behind this is, what the economic impact of this is, and we shall be engaging NACADA in the coming days just to get clarity on this, just so that we can have a better picture of what exactly this means and what led to this. Take a short break on NTV tonight. Stay with us.